What's up guys, Aaron here. This is going to be the Celsius updates, everything that has come through the docket over the last couple days. This may be kind of a boring video, but I just want to keep some of you guys up to date on what's happening. So I will start the video with this. There's nothing that anybody needs to do right now. We are still waiting until the disclosure statement has been approved, which it has not been yet. A lot of what I'm going to talk about in this video are people's objections to the disclosure statement. So there's nothing that anybody, whether you have an earn claim or you have a loan or you are in custody or anybody, there's nothing you need to do right now. So if that's all you tuned in to hear, then you can leave the video. If you want to get into the nitty gritty of what I'm going to talk about, you can hang out with me. What I'm going to talk about is some people wanting to certify the CEL token holder class. I'm going to talk about some phishing attempts, so more scammy emails coming through. I'm going to talk about some letters coming through to the judge to try to get CEL unsubordinated. I don't know if that's a word, but basically make sure CEL is not subordinated. A motion saying that CEL is not a security because of what happened with the XRP ruling, how much White & Case, the law firm representing the UCC, made for June. We then have some drama with Terra or Terraform Labs. I'm going to talk about some of that. Basically, Terra is being sued by the SEC, and they are demanding information from Celsius to see if Celsius was somehow involved in the collapse of Terra. There's a motion talking about the class claim. There are no changes to that, so everything is still the same as it was in my last couple videos. A motion talking about why the class claim and the settlement is a good thing. There is a new SEC lawyer coming in the case. We have Deb with the Withhold ad hoc group voicing her concerns about the disclosure statement. The SEC also has concerns about the disclosure statement. Also, we have Cam Cruz and other creditors voicing concerns about the disclosure statement as well, including the U.S. Trustee, Texas, and Vermont, all having their objections. And then I'll finish the video with Alex's companies. So he has two, I believe, LLCs, wanting to get money from the bankruptcy because his own personal money will not be coming back to him from the NewCo, but he has lawyers saying that his companies should not be treated like his personal accounts and they should still get their money back. So that's pretty bold of him to do so. So let me just dive in really quick. I'll try to make this a quicker video. So there's a motion to basically get legal representation for CEL token holders that are non-insiders, and they want this to be paid by the estate. Then we have about 15 to 20 letters that are more or less cut and paste, all talking about CEL token, basically trying to get support for CEL token. I'm not going to go through them. So let me talk about some phishing attempts really quick. So I have been talking about this in my previous videos, but we will be getting more and more emails that are impersonating Celsius. So they say to make sure to check the domain of the email that you get, which you should always be doing anyway. So proper Celsius emails will come from @Celsius.network, like support@Celsius.network or compliance team@Celsius.network. So be very, very careful when you are opening emails and clicking on links. There's also one I mentioned in a video a few days ago that it's a Dropbox scam. So basically they want you to, send your seed phrase or whatever. Just be very, very careful, especially as we get closer and closer to a distribution, because that's when these scammers are going to get more aggressive. So here is an objection from Santos, who I believe is a pro se creditor, talking about how Voyager creditors who held VGX token got the petition day pricing, so therefore CEL should as well. Also talking about XRP and how XRP is not a security in most circumstances, so therefore CEL is not a security. So he is making his argument here. I'm not going to go through the whole thing, but there are a lot of people that hold CEL token that are not insiders. Alex and his cohorts held, I believe, most of CEL token, but there's a lot of people that held CEL token who were just innocent victims, in my opinion. So we have White & Case, the law firm representing the UCC, for the month of June. They have charged, let's see where it is. I believe it is, $2.894 million. So I am in the camp, which I think most of you guys are, as quickly as we can get out of this process of Chapter 11, the better, because I'm tired of seeing money just drain to professionals and lawyers. So talking a little bit about Terraform Labs and what they want from Celsius. So Terraform Labs, that's the company that had UST and also Luna, and they played a huge part in the collapse of all of these companies back in 2022. So here it says on April 3rd, 2023, the SEC filed a complaint against Terraform Labs, and the SEC claims that Terra falsely represented the ability of this whole UST mint and burn algorithmic stablecoin, and that more or less it was Terra's fault that this thing collapsed. But what Terra says here is that there was a coordinated short attack by third parties, which caused the May 2022 DPEG. And this attack catalyzed massive asset withdrawals from protocols developed by Terra and flooded Celsius and other markets with sell offer orders, transfers, deposits, and withdrawals. So basically, Terra is saying for their defenses, they're demanding that Celsius gives them information about wallets, accounts, and assets that were used to engage in transactions around May 2022. So I remember Alex Mashinsky saying that they got, I believe, most, if not all of their money out of this algorithm or out of Terra before the collapse. And there were some conspiracy theories about because Alex got their money out and other companies didn't, then other companies basically ganged up on Celsius to take Celsius down. I don't know the answer to this. I think a lot of these conspiracies will come out, especially how and if this ties in with FTX and all the intricacies of this web that took out a lot of these companies. And regarding Terra getting these documents from Celsius, Judge Glenn said, yeah, we are going to allow this motion to be expedited and basically allow them to get information from Celsius. I believe it does have to be approved on the 10th. But Judge Glenn says that, yes, it is important that Terra does get this information and Celsius should give it to them. So there is a notice of filing of the class claim settlement. This is a 22-page document. It basically just goes over everything that I've been talking about over the last couple days. Basically, if you do not opt out, you will be bound by the terms of the class claim settlement. Any claims that people have filed will be expunged from the claims register, and they will have no further force and effect, and all of these claims will be superseded by the holder's settlement claim. So this is all review, nothing you need to do. Me personally, I am not doing anything. I am not opting out. I am just going to settle and agree with this settlement. And there is a long paragraph talking about why this settlement is a very good thing. This will settle billions of dollars in non-contract fraud claims, which would otherwise be very costly and time-consuming to litigate. And this will help prevent delays in the confirmation of the plan. People who settle will get that 5% increase in their scheduled claims, and the settlement will reduce the need for the plan to hold back money from creditors. So again, all of this is review. So next, there's a new lawyer representing the U.S. Securities and Exchange Commission, the SEC, this guy William Updegrove, and I looked him up right here, and it says that he represents the SEC in bankruptcy matters. So he is coming into the equation as well. So next we have some objections to the disclosure statement. The first one comes from Deb, who is at Troutman and Pepper. She represents the Withhold accounts, and she gives a couple reasons she does not approve the disclosure statement that basically are all above my non-lawyer brain. So talking about the ADR procedures and things like that. So I trust that she knows what she's doing, and she is representing basically everybody. So next we have the SEC on the disclosure statement, and they have an issue with the tokenized illiquid recovery rights. So next we have a creditor going through a law firm also disagreeing with the disclosure statement. He is representing liquidated loans mostly. So he starts out by saying something that I don't think is going to work. He's saying that earn account claims should be subordinated, but then he goes down here and says basically that the disclosure statement and the plan failed to treat liquidated loans as a class. And there's a lot of people that got wrongly liquidated, and I do hope that liquidated loans does get representation. There is a Telegram group for liquidated loans. I will include that in the description below for you guys. So next we have a pro se creditor, Victor, talking about his issues with the disclosure statement. He says, one, there is little information about the privacy of consumers. Next, he talks about something that's important, the API partners. For one, Bitwala. So this was a German bank that basically partnered with Celsius so people could sign up with Bitwala and also get access to Celsius's Earn program. I guess there was nothing in the disclosure statement talking about that, which is very, very important. He also has some issues with the Celsius mining, a lot of questions here that were not answered in the disclosure statement. So next we have the ad hoc for earn account holders, their issues with the disclosure statement. So they first talk about tax consequences. They say that earn claimants who receive stock can have negative tax consequences as claimants are not receiving a quote, like exchange under the IRC, the Internal Revenue Code. The ad hoc for earn also has issues with governance, saying that there is no commitment to provide earn claimants with seats on the NewCo board of directors, and same with not having a seat on the Litigation Oversight Committee. They also have an issue with the NewCo valuation. They say that there is a conspicuous lack of detail on the methodology and calculation of the illiquid asset and mining company component parts of the NewCo valuation. And also talking about liquidity risk, saying that the valuation of the NewCo equity does not appear to reflect any liquidity risk, saying that this is a brand new company without a trading history, and earn claimants have expressed the need for a conservative valuation of NewCo equity. And also, they talk about the July 31st deadline for submitting alternative wind down bids, and no information has been shared on that. Also, the ad hoc believes that they should decide along with the debtors and the UCC whether to toggle from Fahrenheit to the wind down. Right now, they don't have a say in that. They also talk about there's not information about who benefits from the appreciation of crypto. They say that the distribution waterfall should be clarified to make it clear any excess recoveries or distributions will, in all cases, be distributed pro rata to general unsecured creditors. Incredibly important that they do this in the disclosure statement. And they also talk about this EIP, Emergence Incentive Plan, which is crazy, just giving current Celsius employees an additional $2.6 million in bonuses. They have a problem with that as well. Also, with the FTX claim of $2 billion, they want to know more information about this claim. So next we have Cam Cruz talking about his ideas for CEL token treatment, and there's a lot of interesting information here. Basically first saying that CEL token has no value and is worthless, but then giving this really interesting idea about how to compensate CEL holders pro rata based upon how much money they lost, not just giving everybody the same amount per CEL token, because he's saying that there's a lot of people that have CEL token that bought it for less than 20 cents per CEL, and those people should not be disproportionately compensated, where other people bought CEL token for $5, $6, $7, and those people should be compensated more. And he says here that debtors or their advisors would be able to calculate the outstanding CEL cost value for all customers, and this would be attained by summing the aggregate value of all CEL acquisitions less disposals of CEL tokens. So basically give people the money that they lost, not just give everybody the same amount per CEL token. And also CEL tokens should be distributed, basically given back to people in kind if deemed not a security. Because there are some people writing in, like I talked about earlier in this video, saying that because of XRP, CEL is not a security. And there are also people saying that CEL is worth way more than 81 cents or more than $2. CEL is worth a ton more because FTX was pushing the price down. And what Cam is saying is, well, just give people back their CEL token then. So next we have a very long objection to the disclosure statement from the U.S. Trustee. They talk about third-party releases, and they have a problem with how it was worded in the disclosure statement, talking about this exculpation provision. They say here that the disclosure statement should explain why claimants should be coerced, that's a strong word, to vote for the plan to avoid having an avoidance action filed against them, basically clawbacks. And this is very strong language saying that this is a play on an impermissible and coercive death trap designed to force general custody claim holders into acquiescing to their impaired treatment under the plan in exchange for a waiver of the possibility of an avoidance action being filed. So this has to do with the custody claim holders. Basically, Celsius said that this is your crypto, but we're only going to give back that 72.5%. And in doing so, we're not going to pursue preference actions and clawbacks. And what the U.S. Trustee says is that these types of things are coercive death traps. Next, they have an issue with the Key Employee Incentive Program, basically giving employees more money. Also, they have issues with PayPal, and is there any partnership with PayPal that they didn't disclose, and the debtor should explain why their own platform cannot be used for distributions. Next, we have Texas State Securities Board also objecting to the plan, or basically they file this because they say they may have a problem with the plan. So they do this kind of in advance. And that's more or less what the Vermont Department of Finance did as well. They basically said they hereby objects to the adequacy of the disclosure statement as currently written and reserves its rights to object to the final form. So finishing off with Alex Mashinsky, we have Cheryl Gugliano, or whatever her name is, basically representing AM, Alex Mashinsky Venture Holdings, and she is also representing Koala One LLC, the other company that Alex held. And more or less, they have the same information for both AM Ventures and Koala LLC, and they're objecting to the disclosure statement. Well, here's why. They say that the disclosure statement offers no legal basis and provides wholly inadequate disclosure with respect to equitable subordination and extinguishment of AM Ventures claims in the debtor's cases. Basically saying there's no reason that Alex's companies should have their claims equally subordinated at the whim of the committee and the debtors without any due process, notice, and a hearing, and a ruling from this court. So Alex is doing a Hail Mary and basically trying to get his companies, which I think hold millions of dollars, I forgot how much, maybe tens of millions of dollars, he wants that money. So he's trying to fight for it in court, and hopefully the judge realizes that this is ridiculous and won't allow this. But it is the court, so you can make any motion that you want. All right, guys, that is it for the video. Thanks for watching. Till next time, talk with you soon, and bye for now.